So, good evening, everybody. I call to order the Select Board meeting of Tuesday, November 4th, 2025. You're not able to hear me? Okay, I'll just hold this. I'll keep this close. So, call to order the Select Board meeting of Tuesday, November 4th, 2025. The time is 7:13. If you are able, please rise and join me in the Pledge of Allegiance. For the record, I just wanted to identify that there's a quorum of the Select Board present. We have all members present tonight. We have Mr. Gito, Vice Chair Roberts, Mr. Carrera, Mr. McCrisky, and myself. So we're going to start with the first order of business, citizens' comments. Are there any comments? And Ms. Walsh. Oh, sorry about that. You're right, you'll be next. Thank you.
Cynthia Walsh, 1096 Park Street. I see on the consent agenda a letter of support for BAT. I'm assuming because it's on the consent agenda that it will pass, and I want to thank the board. I also want to inform the board and the general public that right now BAT and Dial-A-Bat are free. They received a state grant and they'll be free until next June of 2026. And this is a boon, especially for those of us who are disabled, because BAT has a longer schedule than the Council on Aging bus. The Council on Aging bus stops at 3, and BAT will keep serving Stoughton until 7 p.m. Also, on Friday, the Council on Aging bus stops at 11 a.m. So if you have a doctor's appointment, Dial-A-Bat again, we'll pick you up until 7. Also, Dial-A-Bat has a limited weekend service. And they also will take me places that the Council on Aging bus will not take me to Shaw's, for instance, at Cobb Corner. They have 2 markets that they prefer that you go to, neither of which I prefer. So I think that the folks that are in the disabled community, if you're not taking advantage of Dial-A-Bat, contact the Council on Aging and see how you can get registered to use Dial-A-Bat. And for everyone in town who's able-bodied and can use the regular BAT run, especially teens, it means that there's a little bit more independence for them to get around, and it also means that parents can rely more on public transportation than having to worry about rearranging their schedule so that they can get their child to different places that are on the BAT service. Thank you very much for your support of BAT and Dial-A-Bat.
Thank you very much. Mr. Fox.
Juan Fox, 624 Pleasant Street. Last May, we passed an engine braking ordinance in town, the Jake braking law, and there are still no signs out stating that this is the case in the town. So therefore, we still have a lot of trucks engine braking right in front of my house. Pleasant Street is a long slope, and so it's a common thing for these dump trucks to come down with the engine braking, and it's really noisy. Anyway, I'm wondering when we're going to get we get these signs made and put up in the strategic places. It really needs to be done quickly because the law exists and nobody's following it.
Thank you very much. I think I might have your email, or at least the town does. I'll check in with the town manager when he returns. He's on out for right now, and I'll get back to you.
Okay, great. Thanks.
Thank you, Mr. Collins. Yes, sir. Please.
Hi, Jack Collins, 30 Barnes Road. I wear this shirt tonight in honor of the Marine Corps' 250th birthday on November 10th. The Army, the Navy already celebrated their 25th. The Coast Guard and the Air Force is going to celebrate theirs shortly. The reason why I'm making a comment is I'm very upset. And first of all, let me start off. I'm very happy that we're changing, or we're, what's the word I'm looking for? Purple Heart celebration, and all the festivities are going to happen. I'm very upset that we're not going to have a parade. And I don't know the reason why. And hopefully, I was hoping Mr. Coulter would be here, or maybe one of the people on the select board could tell me and tell the audience that's watching why we're not having a parade. Is it budgetary? Is it because we have participation, or what?
So I believe that this came from as a recommendation from the Veterans Affairs Office.
I can't hear you, Mr. Cavey.
I apologize. I get used to having this thing a little closer than I normally do. So I think that came as a recommendation from the Veterans Affairs Office. There's no budgetary reason for it. It was, I think, it had to do with attendance, though I don't want to misspeak. So I want to make sure that we get the correct information to you and to the rest of the public. So I'll reach out to them tomorrow and ask for them to reach out to you, or at least give me the information so I can, and give you a solid reason why that decision was made. Now, decisions made, the people in town hall really do their best for everybody. There might be enough people who disagree with this, and we can always change it in the future. And certainly that's something that we're willing to explore. But there was no budgetary reason for it. It really came down to, I believe, attendance.
Okay.
Yes, sir. Yes.
I got a couple phone calls. I heard something about this a while back, Chet, and this year it is only because of the attendance of the Purple Heart event. They're expecting a lot more people, some guests coming in, speakers as well, a Purple Heart recipient, and they're planning more room here and bringing people in, so it's just for this year. There has been talk about the parade because, as you're well aware, is the numbers are dwindling. And,
Yes, they are.
And
Yes.
the people that are marching in it will do it, but actually some members shouldn't be because of their health. And there are some people, you've seen them as well. And so they're struggling with that as well. And I know that, and this comes from the veterans agent and Sharon Johnson, who I spoke with today, is that something has to be done to be a little bit better. But we would not, they are going to have the Memorial Day Parade, but this one for this year was basically just because of this event and the way it was going to be run. And it was too much to do the parade with that, with the longer time. They figured it was a lot. They were talking possibly an hour and a half to do this presentation with speakers and so forth. So I think it was just more that, by what I took away from the veterans agent and from Sharon, is it just so much time with some of the people that are here. They're tired. I'm included in that. I have to bend over. I have to bend over and tie some people's shoes some days.
I know. Thank you.
So it's just one of those things that, and they decided this year to try to do it this way and not have the parade, but everybody was going to be here. So it's not a done deal. It's not something right now that we're never going to see another parade. They are in talks with it, though.
Okay, I just wanted to say thank you for saying Memorial Day. We might still have a parade or whatever.
Yeah.
But my thing is, a lot of people have spoken to me and they heard on the town website for what's her name, Roberta Harbeck, on the town crier, saying that we're not having a parade. We're going to have a ceremony here for Purple Hearts, which is great. I mean, I don't know how many Purple Heart people we have in town, or if it's a state thing or a nationally organized type thing, which is great. I mean, I respect everyone that went to war, got injured, or even died,
Right.
and got a Purple Heart. I respect that. I served 32 years, 3 conflicts, numerous other incidents around the world. So I appreciate everything, but my concern was about the parade. I mean, I know they're going to still have a ceremony for people, you know, poop arts. I don't know how many, like I said, I don't know how many we have in town, but, you know,
Well, as you
I'm
know,
proud of them, and, you know, I respect them and I honor them.
Oh, sure.
I just want to make my comment known.
yeah.
Thank
Well,
you.
as you know, it's an honor for us to be chosen to be a Purple Heart community.
Oh, that-
And that doesn't come without a little hard work on behalf of the people right across, you know, everybody, right down to Sergeant Major, you know, to you, everybody that does what they do each year. You know, it's an honor for us to be chosen. So I think it was just a logistical thing on not having the parade at that same time. So, but if you want to meet, I'll come up and meet with, you know, if you want to come up, we'll talk with Sharon. She can give you all the details because I don't have everything.
Well, I tried calling the office, but
Okay.
I just got a voicemail.
Yeah, no, they're in and out too, so, but we could set up an appointment, you come in and talk with them.
That's good. I just hope the members of the committee here actually listen to people that making comments. Thank you.
Sorry, before you get up, I think Mr. Carrera also wanted to add something as well.
I never apologize for anything, but I'm going to apologize to you that we're not having a parade. I don't understand it. I have a hard time marching in them. A couple of times I've had my knee worked on, so I had to ride, but I was still there. I got out. That to me has been like a staple. One of the most important things is that I can think back to 9 years. I can tell you where I was those 2 days, Veterans Day and Memorial Day. And I don't know why there wasn't respect put out there. That to me is not respect. So I'm going to look into it. I think there should be something. We should make accommodations for those who can't walk and still want to participate. Mark Hausman, a guy that most decorated man, the service you put in, other people, they want to be seen at those, you know what I mean? The fire department, the police department comes out. I don't understand it. I really don't. To me, it's a slap in the face. That's how I feel.
Thank you, Mr. Kerr. And Mark Hausman is a very dear friend, close friend, and he deserves everything he gets from this town. Thank you. And there's nothing more I can say.
Thank you so much. Is there anybody else who would like to be recognized for citizens' comments? Okay, seeing none. We're going to move on to select board comments. Before I do, I just wanted to introduce everybody to a guest of ours. Sitting next to Mr. McCrisky is a Eagle Scout who's learning about civil government, local government. It's Christopher Ricardo. Welcome, welcome to the select board. It's very much a pleasure to have you here. If your mic's on, if you don't mind just telling us a little bit about yourself and what you're looking to do tonight and also in the future for the town. Thank you.
Hi, my name is Christopher Ricardo. I'm an Eagle Scout candidate out of our local Troop 516. Today I'm here to learn about local government in accordance with the Eagle Required Merit Badge, citizenship in the community. As some of you might know, citizenship is one of the 4 aims of Scouting, and it really, the entire program orders you to learn about all stages of government and citizenship through all stages, whether it be through the world, the nation, your society, or especially your community. I'm here to satisfy a few requirements and learn and become more in touch with our local government, and that's about it. Thank you.
Thank you for joining us. Mr. McCrisky.
Mr. Chairman, you know how all the football players, when they get the Super Bowl and they get in the end zone, they turn around and they yell, "Thanks, Mom," right? Christopher has a dad, Paul, and a mother, Kristen, who's here tonight. Very well-known family in town, and Kristen comes from a long line of golden girls. But it's great that I've got him chained down here to the chair so he can't run after he sees what government's all about. But so this is going to be a great opportunity. So I apologize to my colleagues in the audience if you see me leaning over talking. We're just, kind of trying to give Christopher an idea of how these conversations go and how it builds up to a vote being taken. The residents that have the say that they have, which is the best form of government, is town meeting and our elected body. So thank you, Mr. Chairman.
Thank you. And just also, Christopher, I think you picked the right person, as longest serving member of the select board, I believe, or at least the longest living member of the select board. Served for quite a long time. So if there's anything that can be known, he'll know it. So any other additional comments for tonight? Mr. Krisky, Mr. Carrera, Ms. Roberts,
No, Mr. Chairman.
Mr. Gito. Nope. I have no additional comments. So we'll move on to the next order of business. This item 4 on the agenda. Pursuant to General Law, Chapter 44, authorize the issuance of, we've got 3 items here. 1-year, $400,000 sewer bond anticipation note, a ban. A 10-year, $330,500 INI MWRA loan. And the last item is $400,000 MWRA Community Septic Program, Massachusetts Clean Water Trust interim loan. Ms. Newt, floor is yours. Thank you.
Thank you for having me. And good evening to all of you. It's always good to see you. So you have 3 items in front of you, as the Chair Board did mention. You will be voting and approving the 1-year $400,000 sewer bond anticipation note, which is also known as a ban, a 10-year $330,500 INI Massachusetts Water Resource Authority, which is also known as MWRA, and a $400,000 Community Septic Program Massachusetts Clean Water Trust, which is also known as the MCWT. That is an interim loan. For the $400,000 sewer ban, the winning bidder was Oppenheimer and Company. Oppenheimer and Company offered the town a coupon rate of 3.75 that came with a $50 premium, which brought, just so funny, I'm sorry, brought the net interest cost rate to 3.74. The town was eligible for an MWRA financial assistance in the amount of $1,322,000 towards the town of Stoughton's I&I sewer projects. $991,500 is going to be a grant, and $330,500 is a 10-year interest-free loan. And the last item is the $400,000 Community Septic Program Mass Clean Water Trust interim loan. Those funds will be lent to the Stoughton homeowners that are having issues with their septic systems. The town will not have to pay the $400,000 to the MCWT until the funds become long-term debt, which will be when the MCWT 2025 Community Septic Program ends or the town has lent the $400,000 to the homeowners in full. When one of these occur, the $400,000 will become a 20-year loan with an interest rate of 2%. And that's all I have.
Thank you. Are there any members of the board who have any questions? Okay, seeing none, we were provided with a short version of a motion, still a little on the long side, so I'm going to read it, but it beats what we sometimes have had to read in the past, so I appreciate the summary. So I'll read this, and if anybody wants to make the motion, they can just say, so made. So the motion is, I move to approve the vote of the board as prepared by bond counsel to the town and presented to this meeting, which votes, among other things, formally award the note to the low bidder determined as a competitive sale held on October 28th, 2025, and establish the terms thereof. I also move to approve and adopt the votes of the board as prepared by bond counsel to the town and presented to this meeting, which votes, among other things, approve the issuance of the bonds to the Massachusetts Water Resources Authority, and Massachusetts Clean Water Trust. I approve the terms of the related loan agreement and financial assistance agreement, authorize the treasurer to determine the terms of such bonds, and approve and confirm all actions taken to date to carry out the related project and its financing. The formal terms of the votes prepared by bond counsel to the town and approved by this motion shall be incorporated in the minutes of this meeting.
So made.
Okay, so that motion was made by Vice Chair Roberts, seconded by Mr. McCrisky. All in favor say aye. Aye.
Aye.
Any opposed?
I'm going to abstain, Mr. Chairman.
Okay, one abstention. So it's we have 4 yes, 0 no, 1 abstention. Thank you very much. I appreciate it.
Thank you. Have a wonderful night.
Have a wonderful night. The next item on our agenda is a remand hearing. This is related to an earlier hearing that the Select Board had on a dangerous dog hearing. I'm going to pass the gavel over to our Vice Chair. Technically, I think this is not necessarily a public hearing, but it's a continuation or a component of a public hearing. So I just wanted to give her the chance to see this through to its completion. Ms. Roberts, here you go. Thank you very much.
Thank you, Mr. Chairman. Motion to open the remand hearing.
So made.
Second.
All in favor?
Aye.
And I vote aye as well. Attorney Chaplin.
Thank you, Madam Vice Chair. Thank you, Mr. Chair. To frame the proceedings, this evening we have a remand hearing, which is something fairly common in the world of zoning and planning, perhaps not as common at a select board, but the select board does serve in a quasi-adjudicatory function in a number of contexts. One of them is where we have a dog attack, and in this case, we had an incident that occurred on June 9th. It was investigated by the board. A hearing was opened on August 19th, continued to a second night on September 16th. The board issued a decision on September the 18th, and an appeal was taken by the owner of Chase, Ms. Lee, and that appeal was taken to the Stoughton District Court, and the matter has been remanded by agreement because there was an argument that Ms. Lee was wishing to make to the District Court, and we have arranged it so that that argument can be made by counsel, Attorney Jeremy Cohen, Boston Dog Lawyers, who's been engaged by Ms. Lee, and that argument and presentation can now be made to the board in the first instance rather than to the district court. So without further ado, Attorney Cohen, welcome. I will hand the floor over to you for your presentation.
Thank you, Attorney Chaplin. Thank you.
Sorry, there's a button right on front of the mic. If you just mind pressing that once and it's on green, you're good to go. Thank you.
Excellent. Thank you, Attorney Chaplin. Thank you to the board for giving us this opportunity. I have submitted some paperwork to Attorney Chaplin. I have hard copies here, which contain 1 or 2 more pages than before. So my name is Jeremy Cohen, and I'm representing Francis Lee regarding Chase. And I've had an opportunity to review the 3 prior hearings, look at all the reports that have been submitted, listen to the testimony, and I think that I'm not here to say this didn't happen. The facts are what they are. I think the animal control officer, when she finally made it to the hearing, explained what the facts were to the best of her knowledge. And I know this. I know if Mrs. Lee was aware in the past that this dog had scared her neighbors or anybody, she would have taken immediate steps to make sure that never happened again. So with that, I'm here to propose that the board reconsider its decision to deem the dog dangerous and instead consider deeming the dog a nuisance dog for the following reasons. As we've heard from the animal control officer, Chase has no priors. There's just simply no record of any priors with the dog. And we've seen from the Lee family just a a whole host of ways that they've been accountable without being forced to be accountable. And that's rare. This is probably my 200th hearing, and it can take a lot to get clients to the point where the Lees are already at. Hey, this is our fault. Here's what we're doing about it. They've invested $17,000, $18,000 in the fence, and I know you know all that, and the fence went up a couple of weeks ago. And the condition of the muzzle, again, that's something they're accepting as a family. I know that there was a recent complaint that the fence that was installed may not go all the way to the ground. And that's, A, because Mrs. Lee was not aware that it had to go all the way to the ground because her dog's not a digger. But also, to install the fence, they had to dig up the yard. So you'll see in your packet there's a 2-page quote from a landscaping company that will come in and will clean up the yard and bring everything to it's at the base of the fence, even with the grass. So there won't be those gaps in the fence. You purposely pushed out 2 hearings so that the animal control officer could be here. And the town manager made a big deal about let's get her in here. There was concern from Mr. McCrisky that you heard facts that you had never heard before and had no way to verify it. But then she came in and she verified it. And as the smartest person in the room regarding dog behavior, she answered several of the questions that had come up in prior hearings. When this dog bites, the question was, does it then have a propensity to bite? Does it have a propensity to want to, if it tastes blood, to then seek out the taste of blood? No. And she explained that Chase is a good family dog and certainly under control when she is visited. In addition to the items that the hearing authority has ordered, Mrs. Lee has also undertaken to have a new internal protocol. So this developed because she would come home from work, Chase would come out, would be let out the door, say hi, welcome home, and run back in. Well, that doesn't happen anymore. And so there's a protocol in the house where anybody there knows not to allow that. And also Chase is kept in a different room if somebody is going to the door. And there's a picture in there of the sign that Ms. Lee put up saying, hey, remember, this is Chase's room, this TV room, and that's where Chase will stay, especially if there's people at the door. She's also engaged JM Pet Resort for training purposes. They're in Brockton. They're familiar, at least to your animal control officer. And Chase has previously gone there for medical reasons. They're also a veterinarian, but she's scheduling a consultation. I spoke with the owner of JM Pet Resort tonight, explained to her what we're looking at, and that Mrs. Lee wants to engage in training. She also paid all the medical bills. So often at this hearing level, we don't have that person already at that level, and the board has to, well, you can't force them to pay, has to mention you didn't pay your bills, or your dog wasn't licensed or up to date, and here we know that Chase was. So we know we can trust the Lee family to manage the dog appropriately. There was, Mr. Cavey read a definition into the record at the beginning of deliberations regarding what a dangerous dog is and what a nuisance dog is, and his quote was, I cannot fit the facts as we know them into the nuisance definition. Well, I can, and here's why. Part of the statute, in addition to the definitions, state that no dog shall be deemed dangerous based on its breed, and that no dog shall be deemed dangerous if the dog was reacting to another animal or to a person, and the dog's reaction was not grossly disproportionate to any of the following, one of which, the first one, the dog was protecting or defending itself, its offspring, another domestic animal, or a person from attack or assault. That statute is written from the dog's perspective. Was the dog provoked? And everybody in this room, including animal control officers, said the dog was not provoked. That's just not accurate. The dog, being startled by this young girl jumping out of the tree, absolutely sensed that there could be an imminent attack or assault being the fear of something bad happening, and behaved in a species-appropriate manner, and that he needed to check out what is happening here. And in the picture, which you probably already know, that tree, while it is on the property of the neighbor, it is right at the driveway. I mean, and dogs don't know property lines, but this dog chases, this is my region, and my person is right here, and something I'm not used to just happened when the girl jumped out of the tree. So he did not thrash, he did not make multiple bites. It's still a dispute whether he scratched her or bit her, but we know he made contact with her, and ultimately that's unacceptable. And that's why at JM Pet Resort, they're going to work on not just Chase's ability to stop running when the thing it chases stops running, but for Mrs. Lee and her family to be able to say a word to Chase, come, stop, and have that kind of recall take place for Chase. And JM Pet Resort can tailor the training to that. As we heard from the animal control officer, trainers have, as she said, tips and tricks to do that. Looking at it from this perspective of the statute, not just in the definition, but under actual 157 little a, which I just read from, I believe the facts can fit Chase into the definition of a nuisance dog, because Chase could be excluded from being deemed a dangerous dog for the reasons that are cited. Also, we heard information that there's been a number of scary priors with the neighbors, but that Mrs. Lee testified she was not aware of those, and animal control officer was not aware of those. And while it's just one snapshot in time, I have submitted a picture from summer of 2024 where these children who, it was testified, they see the dog, he looks scary, he growled and looked angry. They're in the yard, in Mrs. Lee's yard, with the dog who's on a tie-out, and they're hanging out with the dog. So I just want to make sure and assist the board in getting to what I think is the right decision the right way, and I think part of that is to sift through everything you heard and look at what are the actual facts here. And I think that the Animal Control Officer's report covers that. And I'm asking the board reconsider by deeming Chase a nuisance instead of dangerous. You don't lose any power. Even in your notice of the hearing, you even cite in your letter that under 157 capital A, you have the power, if there's noncompliance with an order, you can seize the dog. It can be criminal in nature. There can be fines. You can actually make it so the person can't even license a dog in town. And so you have the same power whether or not Chase is a nuisance or danger. It's just as long as there's an order in place. And with that, Mrs. Lee can come up if you want. I'm certainly happy to answer any questions you might have. And thank you for your time.
Thank you, Counselor. Do any of the board members have questions for counsel or for counsel's client? Mr. Chair?
Thank you. And I appreciate you quoting actually me in this case, because my concerns were strictly with just the definition as I read it. And so I did read through the section that you referenced, and I'm glad you highlighted it, because it was worth at least a look at it, right? So, but I'm going to ask some questions related to that, and it sounds like you might feel very comfortable answering those. The exceptions, so we've made a determination the dog was dangerous based on the definition that was presented in Chapter 140, Section 136A, right? Sure. And that's specifically that a nuisance dog, there's really no reference to biting a person, and dangerous dog, there is a reference to biting a person. That's sort of the foundation of that. And my understanding of your argument is that there's certain circumstances where that definition doesn't hold. And that's defined in Section 157A. But I want to make sure I understand which section, or what specifically the language is that you're referring to, because it's so the following are true, right? Solely based upon growling or barking, or solely growling or barking. We're not saying that. It's not because the dog growled and barked. Second is based upon the dog's breed, upon the breed of the dog. I don't even know what the dog's breed is, so I don't think that really qualifies. So I think it's number 3. The dog was reacting to another animal or to a person, and the dog's reaction was not grossly disproportionate to any of the following circumstances. There's 4 of them. The first one, the dog was protecting or defending itself, its offspring, or other domestic animals or a person from attack or assault. Do you believe that that's the exception, or maybe one version of the exception?
Yes.
Okay.
I believe that is, especially the was not grossly disproportionate.
Okay. So you believe from the dog's perspective, it felt like it was being attacked?
No, from the dog's perspective, there was something that scared it or made it sense that there was an attack or an assault, just the fear that suddenly he had to go into protection mode for either himself, his person, his property. Okay. So my understanding is that contradicts what the ACO, the animal control officer, was arguing, which is that it was a prey response. And it was, in fact, a response that goes towards the dog attacking something as though that other thing was prey, not as though it were being attacked. Well, she also said that in her response, she also said that he went to investigate the thing that is moving, and then he investigated it, and then he came back. So she also said that. Now, she's not a dog behaviorist, but the point was that you wanted her at this hearing. She should have been at the first hearing and the second hearing, because the complainant has to be at the hearing and be under oath. And she has stressed time and again that this is not a dangerous dog. So prey drive, and prey is a negative word, but prey drive is in every dog. And what we see is with Chase, he didn't act on his prey drive because, and we don't want dogs to act on their prey drive, because dogs who chase a squirrel or a rabbit, that leads to an attack. That didn't happen here. And so, like she said, he investigated, what is this thing? I don't know that you could have trained a dog to be sensitive to something jumping out of a tree when it was there, but it's prevented now because of using better equipment, better dog management.
Okay. So we might have to come back to that one. The second component was a person who was attacked or threatened by the dog was committing a crime upon the person or property of the owner or keeper of the dog. I'm assuming you're not making that claim.
I'm only citing to the one exception. This is a big statute. It's a complicated statute.
Sure.
I'm on the
saves me a ton
legislative
of time.
committee
So
to correct the statute.
It's only the first one.
Yes.
Number 1.
Right.
Okay. I appreciate that. And so just as a follow-up, the recommendation of the ACO was for Chase to receive training specifically to reduce that prey drive. And your argument is that was not actually a problem at all. Instead, the dog was attacking in defense of its own safety.
Well, when you look at the statute, it doesn't say the dog was exercising its prey drive. It says if there was a provocation. Well, you've read the language. So I'm not a dog behaviorist, but a trainer is going to say prey drive, recall, whatever it is, this dog is going to get. You can't train prey drive out, but you can train the person who's managing the dog to manage it better. I don't know the training techniques. I don't know whatever you want to call it. I don't want to be caught in some game of words here because I didn't say prey drive and she did, because that's not why we're here. We're here because the actions of this dog don't fit the definition of being a dangerous dog. It's had no priors. This was an unusual event, and it's simply in the history of cases that I've handled before boards, this is not a dangerous dog. And part of it is that the animal control officer recommends training. We all agree there should be training, but as you know, under the dangerous label, the board can't order training. And so under nuisance, this can be part of an order that she has to comply with. And frankly, the animal control officer would get progress reports from JM Pet Resort to say, they're coming to training as they're ordered to. This is what they're doing. Here's where I think the dog is at. Or they'll say the dog needs more training, or they're not good managers of it. I mean, these people, especially JM Pet Resort in this area, they have a reputation to protect. So they're not, if they work with the dog and say, this is a really bad dog, they're not going to just let it go, because that would be on them, to their reputation.
Well, I appreciate your testimony here. I definitely appreciate that you're taking the time to give me that perspective. I will say that, as you might also recall, one of the things I was particular about was really sticking with the statutory definition, not my own opinion about whether a dog is dangerous or not, or a nuisance or not. And so, personally, from what I've heard and seen of Chase, I would not feel like personally threatened by him. I don't think that he's necessarily a menace to society or anything like that. The definition, though, doesn't give us the kind of subjectivity to make that determination. So hearing maybe perhaps some of the language that would allow that, I appreciate you taking the time to explain that.
Thank you. But I would just draw your attention to, and the response was not just disproportionate, and the response was not grossly disproportionate. So there can be a proportionate response, but certainly the approach of either Chase's mouth or claws making contact with the dog, that's just, I would say, the statute in every law is vague, and it's gray, and it's subject to interpretation. And here, I think if you look at the grossly disproportionate piece of it, it doesn't say what grossly disproportionate is. It relies on the hearing authority to look at it and say, all right, is this what happened grossly disproportionate? And so I think that's where you could inject your personal feelings or bias and say, boy, he didn't take a chunk out of her leg, fortunately, so I don't think it was grossly disproportionate. It would be a different story if this dog had an attack that, especially if it was severe, and also if it was multiple. And that's why I think there is some room for the board under that definition. But we can disagree.
One other thing I'll ask, you watched the testimony, and you probably watched it more recently than my own experience with it. My recollection was also that the victim was bitten while running away from the dog, and that was part of the reason why the discussion of a prey drive became relevant, because dogs will chase things that run away from it as though they're preying on it, right? And so that's sort of the point of it. And I agree, all dogs have this, and this is the greyhounds. They have the little, rabbit they shoot around. That's what incentivizes the dogs to start running. But also, every time I throw a tennis ball, it gets my dog going. So when they see things going, they chase after it. That's part of their drive. Now, that to me was all relevant to the idea that this dog was acting on an instinct that was really driven towards preying on things. What you're currently suggesting is exactly the opposite, that a child that jumped out of a tree and ran away was seen as a threat by a dog, and that they thought that the dog's own safety was being threatened. I'm having a hard time reconciling those two things.
Well, I heard a lot of things that were testified to that were concerning, inaccurate, and that the board sat through for two different hearings. So, that's, again.
If you don't mind sticking to the question, I don't know what you're referring to specifically. But is there something that I said that upset you, or okay? So then can we stick to the?
Well,
to the
I'll tell you what
subject.
did upset me. Yeah, sure. But I'll answer your question first, again, by saying I'm not going to play around with the words whether he was doing it because of prey drive or doing it. This was a provocation. Perhaps the animal control officer does not have training in provocation or understand what provoking a dog is. Animal control officers are not trained in dog behavior. Part of their training has nothing to do with assessing the behavior of a dog. She just happened to be, at the time, and still remains, the smartest person in the room when it comes to telling you, here's what I think happened. And you could probably line up 5 animal control officers and they'd say, Maybe something different. She could have easily have said, if she knew more about dog behavior, said, hey, this dog perceives this tree as part of its domain, and suddenly something happens from that tree, and he's going to react. But she would have the experience to say, and this was not grossly disproportionate, but she doesn't necessarily know the terms that the statute cites. But while we're on it, nobody said anything that, your hearing authority, you put in hours, plus all the reading of the information to get to whatever decision you got to. But you didn't deliberate. There was no deliberation. You spent 2.5 hours here over 3 hearings. And all I saw was, once the dog was deemed dangerous, was, once the hearing closed, was you read the definition, and then there was a vote. And Mr. Carrera, who had a lot of questions on September 2nd, wasn't here to get any of the answers to his questions because the animal control officer was here, so he didn't even participate either way in assisting to get to the decision. I mean, I didn't even hear the numbers. I didn't know it was 3-1 until I read the hearing decision. So I'm just saying that doesn't have any basis really on what Chase did. But if we're going to be at these hearings and we're going to take them serious, then we should be getting to the right decision the right way. And I just felt that deliberation, there wasn't a deliberation. It was just you speaking. I'm not saying you got it right or wrong. I think there's wiggle room to improve the decision. But so that's part of my concern as well.
Thank you.
Yes, Mr. McCrisky.
Well, I guess I'm going to go backwards a little bit. I have no doubt in my mind.
Mr. McCrisky, pull that mic a little bit closer to you. Thank you.
Madam Chair, I have no doubt in my mind that the Lee family are good people and trying to do the right thing. But the fact, as you mentioned, Counselor, the fact remains that a 9-year-old girl was bitten. I'm sitting here to make a decision on how a dog is treated that showed the dog's aggression to a 9-year-old girl. I'm not into dog psychology. I'm not into prey modes and all these things. A 9-year-old girl doing what kids do was bitten by the neighbor's dog. Period. Period. That is the fact. I'm not going to forget that. I'm not going to forget that. We've had hearings before where dogs have been mauled in their own cages by the owner's other dogs. We've had a woman walking her dog that was attacked, was about to be attacked, but then you nailed it. That one word stopped that dog. I'm open to something in the future. The Lee family comes back and can show evidence that that's not going to happen. Something that's hardcore, the training, whatever it is, that I would have no problem reacting to that in a proper manner. But this just happened. This isn't following the fence, how the fence is put up, how the dog is trained. There's no facts to speak to that right now. The fact is a 9-year-old girl was bitten doing what a 9-year-old kid does, climb a tree and run. If everybody has to be worried about their child being bitten by a dog playing in their own yard, we have a problem. That's just my personal opinion. I'm here to make a vote based on how I feel about it. I'm not saying that I wouldn't change my mind later on as more corrective action is done and it can be shown that it was a positive act and it resulted in the dog's behavior changing a little bit. I don't know if that's possible. But I just want to, I'm going to be saying the fact that, a young girl was bitten. So I just want to make sure we never lose the fact that that young girl was bitten. Thank you.
Thank you, Mr. McCrisky. Now, Mr. Carrara.
I wasn't really going to speak till you mentioned that I wasn't here and that I had mentioned some things that at a previous hearing brought some attention to what I thought seemed we needed answers to. And I can't help it that the dog officer wasn't here to dispute it, to sign a statement, or anything. But I take offense to the fact you pawned me off like I didn't show up.
I didn't say that.
That's
It's
the
your
way
own
you laid
impression.
it out. And if you want to go at it that way, you don't want to go at it that way.
Are you
'cause
threatening me?
I
Are you
was on
actually
vacation.
in that position threatening me?
Just a minute.
He needs to
Order,
calm down.
Order, please, at the hearing. Mr. Carrara has the floor.
Thank you, madam.
Some decorum from him is
Yes,
appreciated.
I understand completely. Mr. Carrara has the floor.
I'll finish what I got to say. Is that all right with you? I didn't do anything wrong to cause anything. If I wasn't here, I trust the other 4 people have the qualities to make the decision. I was on vacation. I didn't even know this was coming up, and I'm certainly not going to come in here for this and hang out a vacation. That I haven't been on vacation since 2006, so I'm sorry.
You can say whatever you want to say to get reelected. I didn't challenge you for not being here. I just said the
Reelected?
board
What are you talking
said,
about?
I just said the board held the hearing without you, and you are the person at the the first hearing, which you are the one who said, these types of dogs, you know, they go for the weakest one in the flock. You said, and that's why the older sister has had no problems with Chase, and the younger one has. So you are a breed-specific advocate as an agent of the government when you're not supposed to be. You also said, you know, once these dogs taste blood, that's it. You don't know what you're talking about. I just was saying you weren't here to hear the answers and
Well,
responses
when
to
you
that.
can change the fact that I grew up on a farm for almost 30 years, and I saw how animals act, that's the opinion that I draw.
So he's
I don't
interrupting me.
I don't need to have a degree on something to see what picks something out. And they do generally pick on the weak. And I didn't say this breed, so you better
did.
straighten that out.
Here's what you said.
No cross debate. Mr. Carrara, please allow Attorney Cohen to speak. And did you have any other summary? Because we know exactly what Mr. Carrara said. And we also know that we have continued this hearing multiple times because we want to do the right thing. We want to protect the young child who's 8 years old. That's what I recall. Also, we want to do right by Mrs. Lee and Chase. So it's a complicated matter. And that's why we're doing our due diligence in making sure, is the child safe? If the owner agreed to install a fence, is the fence secure so it will not allow any digging or crossing the property line? We're doing everything in our power, thinking of everything from scoop to nuts, of how we can protect a young child who is not an adult, and she cannot be held to the same standards as an adult. She's doing what children do. A dog was doing what a dog does. Now it's up to us to make sure we're abiding by safety protocol and the law. So for you to say that someone on this board was not doing that, that kind of is like, ouch, because we are taking our time to deliberate this issue. So double ouch on what you just said. But even though I just said those words, we're still going to treat this with due diligence and treat it fair and equitably. We still have not heard from Dog Enforcement Officer Carlos, who is on the line. We still have not heard from the Damas family, I still don't know from this large tree that is on their property. It's a large tree. You know, there's some question about how she jumped out of the tree, but that's not the important point. That's why I didn't bring it up. What I did bring up is the fact that the dog bit the child.
Understood.
So with that, I would like to ask another board member who should have an opportunity to speak, and that is Mr. Gito.
Thank you.
Mr. Gito.
Thank you very much. I grew up with dogs. I grew up around other animals as well. My wife was a person who was the daughter of a farmer in town, and I worked in that farm. No pay, but a friend of mine, right? And so I spent a lot of years dealing with animals as well. And as I said, I think when we talked about this at another venue, it's human nature, it's animal nature. If something occurs that startles you, you react to that. I think I mentioned just seeing a sight in a window, but that doesn't make any difference where it is. You become startled and you sort of react to it. Well, we have a different mechanism than animals do in terms of dealing with that. We have the opportunity to think about that a little bit more. I've seen things fall out of trees. People, dogs, not dogs, people, branches, whatever. And it just startles you. And so, based on that, and based on what I heard in earlier testimony, I would think that the dog is not a dangerous dog. I would say that the dog could be a nuisance dog. I understand the importance of protecting children and adults from animals. I really do. We saw in an earlier incident, a dog incident, where a dog attacked brutally a woman, and we saw the dog bites and the bandaging and all the other things, the gore that you wouldn't want to have. And I think that is an entirely different situation than what we were dealing with here. And that's why I would be more than willing to change the decision on the dangerous versus nuisance dog. And I've read, seen what the owner is willing to do in order to protect the neighbor's child, and protect the opportunity to have that dog within the family and to be part of the family. I mean, that's a huge, it's a hugely important issue on both sides. And if we have the same control over the dog, in whether we call it a nuisance dog or whether we call it a dangerous dog, I mean, I see no reason not to do that. But that's just one person's opinion. Thank you.
Thank you, Mr. Gito. Attorney Cohen, please, you have the floor, and we are listening.
Thank you. There's no doubt you're taking this very serious. And
Sorry, we
in
just put the mic a little bit
nothing-
closer.
in
I'm
what I
having a hard time hearing you. I apologize.
nothing in what I said should be construed that you're not taking this serious. You're taking, this board is taking it, this is hearing 4. I wasn't disparaging Mr. Carrera for not being here. I was simply saying he was a participant in one hearing, so perhaps it would have been good to have him as a participant in another hearing. If he wasn't here, he wasn't here. But I was just saying you were involved and engaged, so we never got to, he didn't get follow-up to his questions. But I understand your position, what you have to do for the safety of the neighborhood. And my position is that I think with everything that you've ordered, the safety as remedial measures, as Mr. Gito said, those are going to happen whether you deem it dangerous or not. There has to be some label, though, to make sure that the order stays and is enforceable. And my point in being here was, my goal is to just make sure we get to the right decision the right way, and then there's no problem. I'm just thinking that under these facts, and Mr. McCrisky, after the first hearing, said, we just heard facts that we didn't even know about. We need to have a complete investigation done. And then Animal Control was here with her investigation. And I just didn't think that in anything that she testified to, that there was anything that would convince somebody more. That I thought her testimony was more towards, hey, this dog, well, it was. It's not a dangerous dog. It's a nuisance dog. So I'm just asking that you follow her lead. But there was, because I didn't think Mr. Cavey, he said he couldn't fit the facts to the law. Well, I have a different opinion, so that's why I'm here. It doesn't mean you're wrong and I'm right. I'm just saying under these circumstances, especially though with this particular family, with the Lees and all they did, that in all the cases, if somebody's going to be, actually we're not even asking you to go easy. They're still going to do everything you want them to do and more, including the training. But if a case was ripe for perhaps a change in the label, then this might have been it. If you don't agree, I understand. But that was my purpose in coming here tonight. It was not to say that every fact wasn't listened to and cross-examined, and so thank you for that.
Thank you, Attorney. Now I'll turn it back to our attorney, Attorney Chaplin.
Thank you, Madam Vice Chair. Just before we move on with the hearing, we had a lot of legal provisions kind of floating around, and it's my job to help the board digest all of this legislative work from Boston, basically. And dog hearings are tricky because we actually have 2 statutes that work in tandem. This has been referenced. We have Section 157 that talks about the complaint that comes in and this hearing process that we go through, and that statute includes exceptions that Attorney Cohen had just referenced, but then that gets cross-referenced with Section 136A, which is where the definitions are. And for the benefit of the board, there is some language buried in the definition of a nuisance dog that perhaps I should have brought up at the initial hearing. I try to strike a balance between informing the board, but also letting the board carry out their own process. So the definition of a nuisance dog, there's 3 ways that a dog can be a nuisance dog. One is by excessive barking. That's clearly not this case. 2, by excessive barking that causes damage or interference. Again, clearly not a barking case. 3, has threatened or attacked livestock, a domestic animal, or a person, but such threat or attack was not a grossly disproportionate reaction under all the circumstances. And that is the definition of a nuisance dog. So you can have a dog that attacks that can be a nuisance dog if there's a finding that goes with it that the attack was not grossly disproportionate under the circumstances. I'm not suggesting one way or the other whether the attack was grossly disproportionate or not. That's for the board to decide. But to my mind, and as assisting the board in determining whether or not it would revisit that dangerousness finding, I think that would be the vehicle. Looking at this holistically for all the stakeholders involved, we have not just the dog owner, we have the victim here, we have the family of the victim, we have the community at large. We do have a situation here where, as Attorney Cohen said, the statute for dangerousness says the board has only 7 options to choose from. And this is not a case where it was ordered to euthanize the dog, which is pretty much the only remedy I think wouldn't be available in a nuisance situation. So effectively, everything the board ordered under dangerousness could be ordered under nuisance. The owner is also offering training. And that's the one point I want to point out, is that training is not something a board can order under dangerous, but it is something a board can order under nuisance. And I would just be remiss if I didn't point that out to the board, if that's something that's important to the board, that the board and the animal control officer feel would be appropriate under the circumstances. It might actually be something that protects the victim and the victim's family and the community better under a nuisance finding than under a dangerousness finding. Again, I'm not saying that's my view. I'm not saying that's what the board should find, but that is a potential viewpoint, and that's for the board to consider. I don't know if that spurns any additional questions or if we want to move on to the next witness, but I just wanted to kind of go through some of the more dense parts of the statute in that manner, just make sure we're all on the same page.
Thank you, Attorney Chaplin. Yeah, that does add an extra layer of detail that it makes it a little clearer for me. How about to the other board members? Do you have any other questions regarding the definition? Okay. Please proceed, Attorney Chaplin.
Okay. And I'm correct that the board has no further questions for Attorney Cohen or for Ms. Lee? Okay.
I see no further questions for Attorney Cohen.
Thank you, Attorney Cohen.
I would just say, Christopher, welcome to town government.
Thank you so much.
Do we have, we do have Animal Control Officer Carlos on, and it's not Zoom, it's appearing remotely. Yeah. If Officer Carlos is with us, out of respect for her time, I would ask that we hear from her if she wishes to testify.
Hello, I'm here.
Good evening. Officer Carlos, I'm just going to swear you in since you were a fact witness.
Of course.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth in the matter now in hearing?
I do.
And is there anything you'd wish to tell the board? Obviously, you've testified in this matter previously, and the board's familiar with your reports, but is there anything additional based on what you've heard this evening that you'd like to share with the board?
I mean, I stand by what I said at the last hearing. I don't think Chase needs to be deemed a dangerous dog, and I still stand by that. And I definitely feel like he fits more in the nuisance dog category.
Do any of the board members have questions for Animal Control Officer Carlos?
I'm looking around to see if they do. I know I do have a question. Officer Carlos, are you the one that would go by and look at the fence to make sure it's secure? So where we landed there, the fence was installed, but there are gaps between the bottom of the fence and the dirt, so the ground. So are you the one to do that?
So if requested by the board, I can definitely do that. I generally only do that for kennel inspections, but in situations like this, I can definitely go by and make sure it's a secure fence.
Okay. Thank you, Attorney Carlos. That was my main concern. How about you? Did you have a question?
That was
Mr.
going to be one of my concerns because I didn't know how milk crates act as good protection. And under the main gate, it looks like there's an 8-inch gap that's filled in with, looks like a piece of dunnage that was thrown there. And I'm taking the letter that was put in the packet as they'll secure that with the contractor, and then that'll be that, right?
Yes, that's my understanding. Yes, sir.
Thank you.
May I inquire if the animal control officer knows of GM Pet Resort?
Yes, counsel can have the opportunity to ask questions of the witnesses. Yes, counsel, if you would just come to the table and turn the microphone on.
Thank you. Just have one question for ACO Carlos. Are you familiar at all with JM Pet Resort as a training facility?
I am. I actually recommend people to go there quite often.
Okay, thank you.
Of course.
Chairman Cavey.
ACO Carlos, thank you very much for joining us. I appreciate all of the time you put into helping us on this matter and all of the things that come before us, as well as all of the matters that come before the town with regard to animals in the town. So I know it's not easy work, but you do make it look easy.
Thank you, Mr. Chairman.
Of course. So, my sticking point has really been, to really relate it to just the letter of the law and trying to understand that. And so getting your perspective on that specifically would be helpful. And just for whatever it's worth, I also come from a family that's always had a lot of dogs. We've lived on farms. I've been personally bitten a lot. So I'm kind of like accustomed to it and don't take it too personally. But at the same time, I'm an adult. And so my question really is related to the definitions. I couldn't personally see a way to fit in what had happened into a nuisance dog. It seemed like the reaction was grossly disproportionate because, as I recall, your recommendation was to train a certain behavior out of the dog. It was the prey instinct. And the fact that you need to get sort of train them to be able to suppress that suggested that it's sometimes used inappropriately, grossly disproportionately. And so, and I'm sorry, I'm a little tired, so you have to excuse me. I'm like a little inarticulate. But do you feel that the behavior of this dog was not grossly disproportionate as a reaction?
I do not think so.
Okay.
And I also, if I may add, I think I recommended the training for reactivity purposes, and recall purposes. So when your dog is zoned in on something, having that word that snaps them out of it and gets them back to the owner.
Thank you. Thank you for the clarification as well. I really appreciate it. I have no further questions.
Thank you, Mr. Cavey. And to you, Attorney Chaplin.
I don't have any questions for the witness. Do any other board members have questions for Animal Control Officer Carlos? Okay, hearing none. ACO Carlos, thank you very much for your testimony. Appreciate your assistance, as always.
Of course, thank you.
Is there anyone else wishing to testify? Please come forward. And again, I will remind the witness that this is a remand hearing, so everything that was said at the initial hearing continues to be testimony that's under consideration by the board, so we'd like to limit any testimony to anything that's new that's not been put before the board previously. And I am going to swear you in, however, since it's a new hearing. So please raise your right hand. Solemnly swear to tell the truth, the whole truth, and nothing but the truth in the matter now in hearing.
We do.
I do.
And please turn your microphones on and state your names for the record.
Okay, I'm Rebecca Dama.
And I'm Faisal Dama.
And what new information would you like to present to the board this evening?
Well, I had prepared a testimony. Is it okay if I read it? Or I had submitted it to the board.
If it's in writing and in the record, it's a bit duplicative, maybe more efficient just to tell the
Okay.
board in your own words what's new.
Okay. I mean, that kind of puts me in a weird place because I was.
I apologize. At least one.
I would like to hear. Oh, okay. Okay. I just want to make sure. So thank you again for giving us the opportunity to speak today. Today we're here to provide a clear picture on everything that has happened up until this point. As I shared previously, my 9-year-old has been chased multiple times over the past 2 years by the Lee's dog Chase. Each time he was off leash. Even after these repeated incidences, the family continued to let him off leash to play ball in their backyard. Because of this, we had to create strict rules to protect our 2 children and keep them safe on our own property. The bite occurred on June 9th. My daughter was playing in the tree where the kids have played safely for years. The family has seen them play in that tree almost daily up until the bite. Chase was let out by a family member to greet Mrs. Lee. When my daughter jumped out of the tree, she was terrified of a dog that had chased her before. She was at least 20 feet away. He chased her for a minimum of 30 to 40 feet, starting from the tree through our front yard and into the middle of the road. After the bite, she was able to make it into the house. Immediately after, Mrs. Lee ran into our house to check on our daughter and promised her that she would order a muzzle to make her feel safe. She followed up that same evening by text, writing at 6:09 p.m., "I'm willing to do whatever makes 9-year-old feel safe and secure to play outside. If it means muzzling him, we can do that." So on June 16th, I notified Officer Carlos of the bite. She informed me on the phone that Chase would have to be muzzled anytime he was outside. Soon after, I saw her go into the Lee household, and she gave the quarantine and the muzzle order. On June 20th, we met with the Lee family. They mentioned plans about the fence, but we were still concerned because of the history of chasing our daughter. When we would say he bit her, they would reply, "He chases, but he doesn't bite." And my husband and I kept correcting them, "But he did bite." We continued to see Chase unmuzzled, so we update our Officer Carlos again on June 28th. On June 26th. On June 28th, Chase was tied to a tree for over an hour while the family was doing yard work. Again, not muzzled. I updated Officer Carlos on July 2nd, and she went out that day and gave the family a final notice. That was the first day we ever saw a muzzle on him. The original hearing, Officer Carlos stated that the dog was not dangerous, and we had not reported previous incidences. But as I explained before, this is a new situation for us. There is no handbook for what to do when your neighbor's dog keeps chasing your child. We never once thought we should call the police on our neighbors. We had a friendly relationship, and they knew about the chasing. I had told Mrs. Lee about it, at least the incident that I had witnessed. Mrs. Lee was present in supervising Chase off leash. They had never once denied this behavior had ever occurred when speaking us to in the past or at the past hearing. We did tell Officer Carlos about the previous incidences when we spoke about her with the first time. It was also stated in my daughter's medical records that this was not the first time Chase had chased her. These were provided to the ACO per her request for her report. Officer Carlos also mentioned that Chase has a high prey drive. A dog's prey drive is dangerous if not managed. This deeply concerns us, not only because of the history with my daughter, but we also have because we usually have many children running around our yard, riding bikes, playing tag, hide and seek, laser tag. We believe now that Chase has begun to view our daughter as prey and is hunting her. This pattern of behavior leading up to this shows that this was not a defensive or startled reaction, because of this, we have not had an outdoor play date since. It was also stated during the hearing that the Lee family was confused by the muzzle order. There is a letter from Animal Control dated June 26 that clearly stated, and I quote, "The dog is being quarantined in accordance with state law and is now being ordered to be muzzled when outside in accordance with the town's bylaws." It states in this letter that this notice was received in person. It is very plainly and clearly worded, and in my opinion, easy to understand. On September 22nd, we were pleased to see the construction of the fence begin, and around September 27th, it appeared complete. However, we immediately noticed the large gaps along the bottom of the fence. The Lee family was clearly aware of this because they tried to block the gaps using milk crates and boards. There was another area along the back of the fence as well, and at first we didn't see him in the fence, so we didn't report it. But around October 26th, I saw him running around the fence, unmuzzled, with the makeshift crates and boards in place. These are clearly inadequate to contain a 75-pound dog. I reached out to the board and Officer Carlos on the 30th with an email describing my concern, along with images showing the gap. On October 31st, it appeared that the family had received notice that their fence wasn't secured because they added piles of dirt along the bottom of the gap facing the street. though amount of dirt can easily be dug through by a dog, the fence still doesn't meet the intent of the board's order. As of today, Chase was seen running around and playing in the fence with the large gaps clearly visible. A pitched Staffordshire Terrier's skull on average is 4.7 inches. A general rule of thumb is if a dog is able to get their head under something, the rest of their body will fit. And the gaps that are visible appear to be much larger than 5 inches in places. In addition to minimizing the prior chasings, the Lee family has also shifted blame onto our family. They have stated that in our past hearing that our 9-year-old was at fault simply because she was playing outside unsupervised. Mrs. Lee even told my 9-year-old on the day of the bite it was because she ran away. I want to be clear that she was in our own yard, a place where any child should feel safe. This kind of victim blaming has been extremely hurtful, and it shows that the family still hasn't accepted full responsibility for what has happened. Instead of focusing on proving their dog's behavior and safety measures, they continue focusing and blaming a child and our parenting. That lack of accountability is exactly why we remain concerned about the risk the dog poses. From day one, the Lee family has failed to follow through, from not muzzling the dog as ordered, to making false promises, to failing to secure their fence properly. This pattern of noncompliance makes us fear for our daughter's safety if the dangerousness label is removed. This was not a random encounter with a stranger's dog. This is our neighbor's dog, one who lives less than 30 feet from us and who has chased our daughter repeatedly. Each time, his body language showed that this was not playing. From the scruff of his neck to his low growl, or as my 11-year-old stated, he just looked scary. These incidences were observed by me and my children while he was on my property. Last year, before the bite, I had to physically block him from chasing my child further. He was standing less than 10 feet from my door. That was the chasing that Mrs. Lee was outside for. In addition, I will read the definition of a predatory aggression from the June 2013 Canadian Veterinary Journal titled Aggressive Dogs, What Questions Do We Need to Ask? Predatory aggression is usually recognized by the behavior sequence, visual or auditory stimulation, triggering a generally silent and direct approach or chase, capture, and kill the prey. The prey is rarely eaten. Many dogs will chase small prey or animals without capturing or killing them. There is therefore a distinction between chasing, part of the predatory behavior sequence, and predatory aggression, chasing, capturing, and killing prey. Unfortunately, occasionally infants and small children are perceived as prey by dogs that exhibit predatory aggression. As a quote from the article from the American Kennel Club, How to Channel Your Dog and Control Your Dog's Prey Drives on Walks, regardless of any training you do, you will never wholly eliminate prey drive in dogs. The more opportunities your dog has to run off and chase, the more they will continue to seek the addictive high that this provides. This is why management of such an important part of any program you undertake. This is why management is such an important part of any program you undertake. If you have a garden, make sure it's secure. I have provided all of my evidence, including photos, emails, texts, orders, links to journal articles, in addition to the documents that were submitted at the previous hearing. I am sharing them again because the risk remains real and urgent due to his unpredictable predatory behavior, and we need to ensure everyone's safety moving forward. I ask the board to uphold its prior decision to ensure myself, my family, my neighbors, and our community's safety, and make sure all orders are fully enforced.
Thank you. Attorney Cohen, do you have any questions for the witness?
I do. Where's the good?
Want me to move?
We need you close to a microphone.
Here.
I should stay there. Thank you. Wow. Thank you. I just have one question. We're not disputing anything that happened. You mentioned that your fear is if the dog's not deemed dangerous, that these security measures or safety measures that the board has ordered, you had fear if the dangerous label was removed that there wouldn't be a safety. You wouldn't feel safe. There wouldn't be the same sense of safety if the dog is deemed a nuisance or dangerous. But is there anything that you heard tonight from anybody on the board, Attorney Chaplin or myself, that indicated that my clients, if it's deemed nuisance, would do anything less than what they're already doing? In fact, after hearing that they're going to do even more.
They were basically not doing what they were supposed to do from the day one. It took 3 warnings for them to muzzle. It took it's taken them, any reasonable human would look at that fence and say, that is not secure. I don't know what else to do. I feel lost. My child was like, Mommy, they're going to muzzle him, right? Because he's a bad dog. And I said, yes, they will. And she promised me she's going to order a muzzle. She didn't. So
Just my question was, do you believe that moving the dangerous to nuisance, that you and your family would be less safe?
I want as much protection as I can because I don't trust anything anymore.
Okay.
I need protection for my daughter.
Okay.
And that's what I'm asking for. And that's why I've been here fighting. I don't know what else I have to say or do.
Thank you.
No further questions, Council?
Right. Thank you.
Any questions from the board? Hearing none. Mr. Donovan, did you have any testimony you wanted to give?
I just wanted to comment a little bit because a big part of the earlier discussion was around to go to the nuisance dog versus right instead of the dangerous. It was about the reaction being, sorry, what was the wording again? Grossly
disproportionate.
Disproportionate. And I'm playing it out in my head, and I'm trying to think like, okay, that's pretty open to interpretation, right? Like, how do you look at the situation and feel one way or the other? But as I play it in my head, you have a 9-year-old girl that jumped out of a tree, right?
20 feet away.
And sure, I can see if she landed right next to him or something, he might turn and bite. Okay, I can kind of get that. But she was already a significant distance away. What was the number?
She was about
from
25,
the tree from
20
where he
feet
was.
away from Mrs. Lee's car.
Okay. And so he had to approach her that far, but in addition to that, another 30 feet or so to get to the front of the yard near where the mailbox is. And that's where the bite took place. So how do you, it seems very disproportionate to me, both in terms of how far he had to chase, he's just in this prey drive mindset. And are we saying it's okay that he can be in that for as long as he needs to be until he gets knocked out of it by some code word that's trained into him? Or is there a limit to where we say, okay, yeah, he's gone far enough, and yes, that bite is severe enough, which I do think it is. Every time I pull it up in my phone and I look at that bite, pictures of that bite, and I just think of, because I saw it in person too, obviously, and I think back to that, I go, I can't believe this happened.
And on top of that, we have a lot of children in our neighborhood, a lot of children. And, I would have sometimes play dates with 8, 10 kids. So who's to say that all of a sudden, this one kid won't come around a corner and all of a sudden if he isn't secured, then next thing you know, another kid gets bit. I understand that in his house, he is quite a loving dog. I'm not going to doubt that, but I am scared of him outside for my children, for the children I take care of. I don't know what to do.
I have a follow-up question, but I don't want to jump in front of any board members that are prepared to ask a question. Mr. Gito, do you have a question?
I just have one question, and that is the situation that we were talking about at the time of the incident is not the situation that we're dealing with now. We're dealing with a dog that is going to be fenced in, or is fenced in.
But not well.
We're going to, the owner is going to have the property graded so that it will be fenced in well. And so going back to June and saying that, well, that's going to be the situation forever, isn't what we're talking about, I don't believe. And it seems as though we should be looking at the behavior of the dog under the conditions that we're dealing with at the present time and moving forward. And I think it's within that context that perhaps we should be looking at the definition or the degree that the dog is either a nuisance dog or a dangerous dog. And I guess I'm just hoping that we have in our mind sort of the issue as moving forward, as opposed to not having that situation available and, in fact, in progress. So I guess I say part of that to talk about the dog and the issue that we're dealing with, and also part of it in terms of how you will feel as time goes on as well. I mean, I understand that you are very upset, and I'm not saying anything about whether you should be or shouldn't be, but moving forward, I hope whatever conclusion we come to with the dog in place in that house, in that yard, that you can feel more comfortable there. Thank you.
Do any other board members have questions? I do have a couple follow-ups. So I just want to make sure the record's clear, and you're right to be concerned, so I just want to make sure we understand what those concerns are. So one concern, as I understand it, are the gaps shown in the photographs between the fence and the ground.
And they're on the back and they're on the front.
So you would request that the board order that those gaps be closed?
Well, just that the fence would be secure, which is what the order was prior, which is the original order, that the fence is secure. There's gaps that are like this big, that appear to be this big, I should say. I mean,
So you would, in terms of the fence, your position is that the original order is not being complied with. You would like it to
Correct.
be complied with?
Correct.
Okay, so you're not looking for any change in the order relative to the fencing?
No, we
You're
just want it to be complied with.
complied with?
Yes.
Okay. The other aspect of the order is muzzling, and is your position the same? You want that muzzle order to be in place, but you want it to be fully complied with?
Yes, and it is being currently complied with. After the final notice was given, it has
Okay.
been complied with.
And
So,
then,
but-
as I understand the position of Ms. Lee and her counsel, they are willing to be ordered to do training with this JM Pet Resort that the animal control officer recommends and is familiar with. Is that something you would like the board to order?
I mean, that's where I don't understand how this process works. I mean, I just hope that this dog can never look at my daughter in the eyes again. You know what I mean? Like, that's my biggest thing. I just wanted him to be away. Like, keep him in his fence or keep him in his muzzle, and we will be forever happy. You know what I mean? Like, as long as he is secure and away, then we're happy. I think whatever training they want to do, as long as he stays away, that's fine. I mean, it makes sense, but I just wish that there was a way to keep him just never looking at my daughter again.
Yep, I would echo that. Like, just minimize the chances that he could possibly interact with any of my daughters or any other kids that are playing in my backyard that don't.
Does training hurt, in your view?
No,
No.
I mean,
Sounds good.
No, not at all. But it's just, I don't know how this works. Sure, training, go ahead, absolutely. You know what I mean? Our number one priority is that they never face each other again. You know what I mean?
Safety.
Yeah, safety.
I mean, that makes a lot of sense. If training is added in addition to the conditions,
Well, that was already one of the conditions, I thought.
No, that as a point of law, the dog was deemed dangerous, and therefore the board lacks legal authority to order training. If it gets changed to nuisance, the order can stay and training can be added.
That's weird.
I don't disagree. That's, I didn't write it, and I don't know why they wrote it that way. Yep. Okay, I understand your position. I just wanted to make sure we understood what you were asking the board to do. And now I understand. Mr. Gito?
I said I do not understand her position. She either would rather have the training or would not want to have the training.
I guess I am not a lawyer. I am not someone who interprets law. I don't understand. Obviously, I would want everyone to remain safe with the fence, the muzzling, and if training works, then that works. You know what I mean? I'm saying my number one priority is just
I understand that, but the issue is if the dog is a dangerous dog, then the training cannot be implemented. But if the dog is a nuisance dog, then in fact you can add that and provide perhaps a little bit more protection. I think that is what counsel is saying. If I'm incorrect?
That's correct. It is a
So
peculiar.
what
it a
is your
peculiar
position
statute.
on that?
I mean,
Can I? So I think I understand it, and it is kind of odd that it works that way. It sounded, am I incorrect? It sounded like the Lees were interested in doing that training anyway, or were they only going to do it if it came down to like a nuisance? I don't know. But my biggest concern is his ability to get out of that fence and get free. So training, sure, would be great, but if we can like get as close to a guarantee that he can't get out of that fence, I think that would be really valuable to me.
If I might, my understanding is that the fence is to be put up, it's to be secured, the dog is supposed to be on a muzzle, aside from the fact when he's outside within that fence. And if conditions arise that the fence isn't there, or the dog is not following the protocols that we've indicated, then in fact we would have another look at that situation. So there are no 100% guarantees in life, but the order is to do the things that you want to have done. And we are looking at it from the point of view of that being the way to deal with what you want to have happen. So that is the part that we're talking about, and we're talking about the training as well. And I think I just heard you say, well, it wouldn't be bad to have that. So if that's the case, then that gives you a little bit more protection. At least we would think that at least I would think that that would be the case. And it provides an opportunity for the dog to be considered a nuisance dog instead of a dangerous dog. And we could go from there. The same protections are in place for you in terms of the dog being fenced and appropriately muzzled when needed. So I think that we're trying to get to a yes here, if we can do that.
I mean, may I ask a question? Like, because right now the fence is, in my opinion, not adequate. I know you mentioned that the ACO, that Officer Carlos, would may be able to look at the fence and deem when it's not adequate. Like, should they not be using the fence then with him?
My understanding is, and I believe the attorney has just indicated that the fence the land would be regraded.
Yes.
So that the fence would come down to that, or the land would come up to the fence, I guess, and would deal with the issue of not having a gap
Yes.
there.
No, and I understand.
Now, there's somebody else. Let me stop talking.
So Attorney Cohen has a question.
It builds off these back and forth question that if there is a question that, so there's a question that the fence isn't doing what it was supposed to do, and it's just a fence company, they put it in 2 weeks ago, so it's going to be fixed, but until that time, since technically it's not a secure fence, so the Lees will just now keep the muzzle on in the yard until everybody's comfortable that there's a secure fence. So that's an easy interim fix, I hope.
Are there further questions from the board?
Yes, sir. Yes, Attorney. And what Attorney Cohen said is the line of questioning I was going to have. But I am also concerned, you brought a picture, your main concern seems to be the fence. So I would like to stick with the fence.
Absolutely.
For everything about the fence. Before, there was no fence. Now, there is a fence. It looks to be of the height that would make you feel secure. The gates and things seem to be secure. The only problem you have is the bottom of the fence to the dirt.
Yes.
Also, we heard testimony from Dog Officer Carlos. She said once it is fixed to make it totally secure, she will be responsible to come by and check that.
Okay.
And report back to us.
Okay.
The board. And I think that's the final step.
Yeah.
So,
No.
in my opinion, I don't feel comfortable changing anything, and I could be convinced otherwise, but I don't feel comfortable changing any of our decisions until the fence has been secured, because that's outstanding. But the definition, we talked about that a lot, but I want to see everything complete, and that's just my view. That's just my personal view. Chairman Cavey?
Yeah, so I suppose this question is for Attorney Chaplin. Some of the proposals seem like negotiations in a sense, right? So the question is whether, there's a statement made by a previous speaker that whether or not an order can be implemented or not implemented based on whether it's nuisance dog or dangerous dog. I would amend that just to, and really the choice of language I think is inaccurate, because it's not that they can't be implemented, it's that it can't be
ordered.
It can't be enforced, right? It can't be ordered. But the fact is that I haven't heard any testimony that the dog owner has no intention of training the dog unless we force her to, right? So that's one thing. I do feel a little uncomfortable trying to find a result and fitting the facts to arrive at that result, rather than trying to determine the facts, and then the result is going to be whatever the result is. And so as a member of, in this case, sort of this jury, so to speak, I don't feel comfortable negotiating a result that I want. What I want to see is if I can understand the facts and arrive at something that I believe to be true based on that. And then whatever it is going to be, whatever it's going to be. And we're going to have to figure that part out as part two. I do have, everything comes down to this notion of an action that's grossly disproportionate, ultimately. That's sort of the controlling language here. And it's whether or not the action is grossly disproportionate, yes or no? And, coming into this, I felt 100% sure it was. Then I started to feel a little bit of coming towards 50%. I am finding myself going back, maybe not to absolute certainty, but certainly to the extent that I'm able to determine. The facts that I know is that the child posed no threat to the dog, no actual threat to the dog. The dog initiated the aggression from a distance, and that in this case, the bite was not necessary to defend itself against any of these actions, against that action. So it was an unprovoked attack. It's hard for me to say that an unprovoked attack from a distance, you can find some sort of a justification for, sometimes these things happen. That seems disproportionate in this instance. And I'm having a hard time finding a way to get to it being, something other than grossly disproportionate. And so I'm still finding myself in exactly the same place I started. Maybe there's a case enough that if brought to some other body or to a court or something that they might arrive at some other decision. I can't say. But based on my understanding of these rules, the law, the circumstances of the case, regardless of what the results may be, I'm still having a hard time seeing this not as a grossly disproportionate action by the dog, and that it still, to me, fits the definition of a dangerous dog. I'll say now again, I don't think that here we're using the statutory definition of what a dangerous dog is, and strictly, I can't say if the dog's a good dog, a bad dog, dangerous all the time, some of the time, almost never, but only once. I really don't know, but the definition that's provided to us by the statute, I still feel fits the circumstances of this case. So I just wanted to share that.
Thank you, Mr. Chairman. Mr. Carrara, did you have a final comment before we close this public hearing?
I think what it boils down to is it's coming to the word of trust. And the trust has to be on the dog owner, that the neighbors have to trust them to take care of their dog. So it's asking a lot of them, and I can understand why. But I'm confused, like Mr. Cavey is, to a point that I understand what one word means for us here to levy stuff, and another word kind of pulls power away.
Thank you, Mr. Carrara. Mr. McCrisky? No further comments? Attorney?
So, Madam Vice Chair, it would appear that the board does not need more facts to make its decision. So I think the next step is a motion to close the hearing. And then just to sort of remind folks who, it's been a while since we've had this, the first decision that the board has to make, and the chair is exactly right, is whether the finding is dangerous or whether the finding is a nuisance. It's effectively like a guilt or innocence phase. And then the board can move on to the next question after that, which would be, sort of the sentencing phase. And the chair is correct that oftentimes in adjudicatory proceedings, we don't get to the end result, i.e. the sentencing, before we deal with the guilt and innocence. I will say, when we have, this is, I would say, more akin to a bench trial or a jury waive trial. So oftentimes in those types of proceedings, everything does get blended, as opposed to a jury is not allowed to know anything about the sentencing. But you're absolutely right. The findings should be supported by the facts, and I would submit that the board needs to deliberate. I can instruct the board on that, but probably more orderly if there's a motion to close first.
Before you do, a point of information to Attorney Chaplin. Given this is a remand hearing, which honestly, I've been doing this for a little while. I think it's the first time I've ever done this particular type of hearing. I just wanted to ensure, we have already provided a determination of dangerous nuisance or neither, and we've already provided the remedy for that. Do we do that again, or do we now have the option to take no action, essentially let the previous decision stand? or like, what are our options of what these motions can look like?
The court order instructs the board to issue a new or amended decision.
Okay.
So it's as if we're doing the process all over again. Is there a motion to close?
So made.
Second. Mr. Chairman, second. All in favor?
Aye.
Aye.
And I vote aye as well.
So that brings us to the first question, whether Chase is, yes, the witnesses may step down. So that brings us to the determination whether Chase is a dangerous dog, a nuisance dog. That's obviously the complaint is not going to be dismissed based upon the tenor of the proceedings. And as has been discussed, the question is whether what Chase did was grossly disproportionate under the circumstances. All I can really tell the board is we look to the statute as a whole. So there is some recognition in the statute that a dog can behave disproportionately under the circumstances and still be a nuisance dog. As to whether something that's grossly disproportionate has to be far in excess of something that's ordinarily disproportionate. As to what that means, it's not really what it means to me. It's really what it means to the board. And I would submit, I think the board members have to discuss that amongst themselves, and it's quite possible different members could feel quite differently, reasonably feel quite differently about that.
So,
Attorney.
Yes, Madam Vice Chair.
So if question regarding the current state is we declared as a dangerous dog. Is it doable, or what is a practical approach? If we wait until after the training, can we change that decision at that time?
No.
Or will he indefinitely be declared as a dangerous dog from this point forward?
There will be no opportunity to revisit the decision that is made this evening. If there's a subsequent incident, that incident could trigger a new hearing, and the board could make whatever order it deems appropriate at that time, including remedial measures beyond fencing. The board could order that the dog be put down if Chase attacks again. But that would be a whole new hearing. The question here is what becomes of this June 2025 incident. And the prior order was a finding of dangerousness with the remedial action that's ordered. So the board now is deciding in this moment whether that finding of dangerousness stands or whether the board will revise that to a finding of nuisance based on the discussions this evening.
Is the board ready to make a motion? Or do you need time to think about it?
I'd like to make a motion, though. I think a debate afterwards would be perfectly appropriate if people feel like this is I'm wrong here. Well, I'll need a second first, so it may kill itself. But I don't. Though there have been some new facts presented and some new information and some very thoughtful, meaningful things for us to consider in our determination, I still feel that the facts of the cases they've been presented to me cause me to believe that this dog should be deemed, according to the statute, a dangerous dog.
Thank you, Mr. Chairman. Is what's adding to your definition about this, is it relevant to the point or a distance from the point of Chase leaving the house and crossing the property line to the tree and then all the way to the front door of the DeMoss family? Does that add into your decision?
Yeah, I mean, that's certainly a factor. It's
proximity.
Yeah,
and
that it's the proximity, the action, the resulting behavior, I think, are disproportionate. So and the fact that ends with a bite, they caused injury. So I don't have the statute right in front of me. I apologize, but those are what I can recall. For those reasons, I make the motion that Chase be deemed a dangerous dog.
I'll second that. Or,
So certainly, I definitely welcome any debate to persuade me otherwise.
on the motion, discussion, Mr. Gito.
Yeah, I don't believe that I can change your mind. I have the same opinion that I had before, and I stated it again. There's nothing more that I can say aside from saying what I said before, and I'm just taking up time to do that. I feel pretty strongly about my position, as you do. So we'll just hold it at that.
Thank you, Mr. Gito. Motion was seconded, and that allows us time to discuss. Mr. Carrara.
Through you, Madam Chairman, to our attorney, Mr. Chaplin.
Yes, sir.
If we change, my understanding, change the word to nuisance, there's more control. Is that true?
That's true.
What I would like to say to the Damas family, I want to vote for the best thing that's for you people so that we have the teeth to do what we need to do. I look at it now, there was the bite that bothers me, but I want to do what's best for you people so that if there's something to come back on, that fence doesn't get done and finished as soon as possible and everything else. If it remains that dangerous, I don't know what's going to happen. It might not. Am I right? To a point.
Well, the fence is going to be there whether it's dangerous or
Right.
nuisance. The difference between dangerous and nuisance is whether training is ordered by this board and enforceable by this board, in addition to the fence and the muzzling.
So basically, the training is the only thing. That's
The training is what the board has the ability to order under nuisance, but not under dangerous.
thank you.
Thank you, Mr. Carrara. Mr. McCrisky. All set? I'm all set, too.
The hearing is closed. Were you looking to testify?
Just a quick question.
I can listen to the question. I'm not sure if I'll be able to answer it.
So you said that if the dog was deemed dangerous, you could never take that away and go back to nuisance. If you deem it nuisance, could it go to dangerous?
It could.
So then why don't you just go nuisance, have all the protection in place, and then if that's not met, then you can go to dangerous?
So, sir, I appreciate the comment. That is ultimately for the board to decide. So appreciate the comment, but we're going to have to stop it there.
The motion on the table, which was seconded, is that the definition remains a dangerous dog. So all in favor on the, unless we want to discuss it a little bit more. So, okay. All in favor?
Aye.
No? You're opposed? And I vote yes as well, and no abstentions.
I vote no.
You vote no? So
It's 3 to 2.
so there were 2 noes and 3 yes. No abstentions. So now for the next vote, what are we going to require? We already have the muzzling, but at this, we have to restate that. Is there a motion for the next steps?
I don't have the list in front of me, but I'd like to
I think
move
it was
that we
fence,
that we restate
muzzling,
the
and
same
training.
Yeah, the same requirements that we voted at our last meeting.
Those were the same yes, Attorney.
Just to make the record clear, because I have to write a remand decision in any event, the fencing would include secure fencing to the reasonable satisfaction of the animal control officer.
That reasonable satisfaction of this board. She acts as our agent, and I was going to add something that I want to put a time limit on that finishing of the fence and adding protection for the neighbor there. I don't want it to, well, we couldn't get him in there and winter's coming, so we're going to leave the milk crates. I wonder if we put a date, a time limit on it, 15 days? I think that's fair.
Madam Vice Chair, if I may.
Yes, Mr.
Not that I'm not debating, but I believe there was a proposal made by the owner that Chase be muzzled in the yard until such time as the fence repair is made. And I only bring that up because a 15-day order would put the owner at the whim of the fencing contractor. It might be difficult for us to enforce, in terms of bringing an action in court, getting an injunction, whereas if the order were muzzling in the yard until such time as the repair is made, that might be easier to enforce.
So the motion would be, as stated, fencing. Can you say that again for the record?
So I was asking if it's fencing to the reasonable satisfaction of the animal control officer. A point was made by a member of the board saying they'd like it to be the reasonable satisfaction of the board.
Yes.
Although it sounds like it will be. So I guess the question is, what would the mechanism be? It sounds like the intention is still for the animal control officer to inspect the fencing, but would it be for the animal control officer to report back to the board and then the board to have final sign-off?
That's what we're agreeing to.
Okay, so
So that would be the motion?
that would be the motion. So for the fencing, to secure fencing to the reasonable satisfaction of the board, to the reasonable satisfaction of the board. And I'll draft the decision accordingly.
I'll take that as an amendment to my motion of everything that we already implemented, but to add in that the fencing has to be completed to the satisfaction of the select board.
And to the satisfaction of the board, the select board? And
Do you need a second, or is that?
do you want to
Yeah, I
add
think we need a
in
second.
muzzle until the fence is to the satisfaction?
So that is, I think, already part of the
Okay.
order.
Second.
All in favor?
Aye.
Aye.
I vote aye. And so unanimous decision.
So as a point of clarification, between now and the date that the fence repair is made, under that motion, is Chase required to be muzzled in the fenced-in yard?
Yep.
Correct.
Okay.
Yep.
I just wanted to make sure I had it right.
Yes. There are 2 questions going on. I see Mr. Gito and Mr. Carrera. Mr. Gito, you all set?
I would like to know. I would like to know what the parameters are for our decision on whether or not this fence is adequate. If it's not something that is reasonable, it could go on forever, that the dog would have to be muzzled. And I think that if we are going to talk about its being properly done, that the ground level should come up to the bottom of the fence. And that should be the parameter in which we're dealing with. If we don't agree on that, then in fact the owner of the dog is at the mercy of the whim of the board.
I see your point, Mr. Gito.
Thank you.
But I believe that we also agreed that we are relying on animal control officer Carlos to make the inspection.
No, we're not. We're saying that we are going to make that decision. That was the change that Mr. Carrara made, not to have her make that decision.
That's
To
not
have
what I
her
said.
come
That's
to
not
us
what I said.
and that we would make the decision. A decider doesn't have to take the recommendation of somebody who's doing the review.
Thank you very much, Mr.
Thank you,
Gito.
Vice Chair.
Please, clarification, Mr. Carrera and then Chairman Cavey.
What I said was, we make the decisions, not the dog officer. She reports to us, so when she goes out there and gets it, she has to bring it back here so that we know that it's been done. To our satisfaction, not what she thinks, to what this board just put down on paper. So if everything is done, the grade come up like you said, which it has to be, probably has to be raised outside the gate, not just inside. It's going to have to be outside the fence too, because what's going to hold it when you raise that up and you get a wash? It's going to go out underneath the fence and it's going to leave. So these are things.
Let us define what that is, so that we know what the parameters are that we're dealing with, so that we have clear definition of what's going on and what our decision is.
Thank you, Mr. Gito. Chairman Cavey, because I'm looking at a picture and there may be other things that need to be done.
I'm thinking the same thing.
She's on the premises, so she would
Yeah, I think
see.
our reasonable satisfaction, I think, is perfectly adequate. I don't think we need specifics because, if we say, that the bottom of the fun, the earth has to go up to the bottom of the fence, that's great. But what if the locks are made of Jello? Well, that's not to our satisfaction, but it's not one of our specs. Or what if it's only 3 inches tall? Well, that's not one of our specs. So we can either list every single specification required for this, or we can just use our judgment and have it be reasonable. And I think that's perfectly fine with a 5-member board where 3 of us have to agree on some standard.
Any further discussion on
Yes.
Mr. Gito?
So what are you saying that you would
Mr.
like
Gito
to
is
see?
asking.
Specifically?
Yes.
That it be reasonably secure.
What?
That it be reasonably secure. Secure to the degree that a reasonable person can look at it. I mean, like a reasonable person test is like I didn't invent this. This is a typical way of working through.
We have 5 reasonable people here.
Then we should be able to arrive at this conclusion without too much trouble.
No, but we should have a pretty clear understanding of what reasonableness is, it seems to me. Before we have somebody embark upon that. So is it that the ground has to come up to the fence, the bottom of the fence, or not? Or is it something else? Is it 5 inches higher because we don't want to have runoff at some point in time?
So, Mr. Gito, I would rely on Dog Officer Carlos to give us, when she goes out and inspects, she tells us what she sees and says it's secure. Then we, the board, would vote, do we agree that's the definition of security? And then case closed.
And if we vote no, then the dog is still going to be muzzled within that property. So that is the point that I am trying to get to.
Would you like to make a motion of some kind? We can, because like,
No, I have.
then all of our entire order of business for this item has been addressed. Unless there's a motion to do something else, we can move on to the next item.
Well, then, I would say that the ground should come up to the fence.
So your only requirement is that the ground comes up to the fence?
That is correct.
And there's no other requirements?
Well, that is the thing that we're looking at now. We have got a fence. We have got the dog muzzled within that fence until something happens. And what I'm saying is that when there is no light between the ground and the fence, then that is sufficient.
Is that a motion?
Yes.
Okay. I don't want to cut it in, but is there a second? Sorry. Okay. So it's all yours, but it looks like there's no second.
There is no second, so the motion fails.
We're not going to have any criteria.
So, Mr.
Aside from the dock officer going out, looking at the fence, coming back and saying it's okay, and then our saying, well, maybe it's not.
Well, I think it's something, additional steps are going to be taken. The landscaper will go out and fill the gaps under. So the first order is probably Mrs. Lee and her family saying, yes, we agree that is secure, because the attorney, Cowan, did say this was a new fence that was installed. And I'm sure when we hear from the Demise family, they will say, yep, this is exactly what we're talking to. And then when Officer Carlos goes out and she talks to both Mrs. Lee and talks to the Demise family, and she sees for herself that it is secure, and then she brings a report back to us, she has covered and performed her due diligence. And I don't see what other pushback we could give in denial of the action that we're taking.
What is the Demouse family? What is their role in this now that we have heard all of the testimony? We have heard that the fence should be up. We have heard that the dog shouldn't be able to get to the other side of the fence.
Right.
And so we should be able to determine that. The dog officer should be able to determine that.
Right.
And if that happens, that we are dealing with the dog and the dog owner now. Mm-hmm. That is who we're dealing with. We're not dealing with the neighbors at this time.
Madam Vice Chair, just point of order.
I don't believe.
Okay.
Point of order. We have no motion on the floor. All the order, the business is done, and now we're just giving speeches. I think that unless there's going to be some sort of a change in a vote of any kind, I think we're primed to move on to the next item.
Fine.
Of the agenda.
That is what we will do, obviously, because that's the way we operate.
I look for a response from our dog officer, Carlos, with the report. Yeah, but I'm saying for the records, I'm sure she'll get a report that we're urgently looking for a response from her. With that said, I think we're going to the next order of business, Mr. Chairman, and I'll return the gavel to you.
Thank you very much. We've been sitting here for a little while. I know it's kind of late, but I want to give everybody a little bit of a chance to stretch your legs. Yeah, 3-minute recess just to stretch your legs. Welcome back, everybody, to the Select Board Tuesday, November 4th meeting, 2025. The time is 9:32. We're going to skip ahead one item. It'll only save you 5 minutes, but at the same time, we have a presentation, and members of the Energy and Sustainability Committee have been waiting very patiently, and I appreciate your time here. So there is a Climate Leader Community presentation. We have Dave Billow, Energy and Sustainability Committee Chair.
And don't be talking dog houses.
Oh, I think we might be short a mic. Let me grab you one. We got extras. Mr. Billow, great to see you. And I don't think I've met the person sitting beside you. If you don't mind just giving me your name and information. Your name?
My name is Lisa Sullivan. I'm the Green Communities Regional Coordinator. I work for the state of Massachusetts.
Oh, excellent. Thank you so much. Thank you for joining us. Floor is yours, sir.
All right. Well, thank you. Good evening, and we appreciate you giving us the time to do a little presentation for you tonight. We do have a slideshow. Is that something that can come up? Okay.
Sorry? Oh, yeah, Dolores, you raise your hand?
Yes, I could not hear.
Were you not able to hear anybody, or just a certain speaker?
Is Mr. Billow the first speaker?
Yes.
Okay, I'm okay then.
Okay, perfect. Thank you very much. Yeah, if you don't mind just pulling the mic a little closer and maybe.
Sure. And I haven't
voice.
introduced myself yet. So I'm Dave Billow, and I'm here tonight as the chair of the Energy and Sustainability Committee, the Stoughton volunteer group. And will we have the, okay. So we have a little slide presentation, which you should have seen in your packet before, but we can go through that, kind of lead us through about 10 minutes of an overview. So what we wanted to do tonight, both Lisa and I, Lisa was kind enough to volunteer to come in and speak to us in person, is to give you an overview of the Climate Leader Community Program, and maybe at the end ask for your support, the board's support, in moving forward to the benefit of the town. So I've introduced myself. Lisa has introduced herself. We'll have some contact information at the end. Before we jump into the Climate Leader Community presentation, I wanted to just start with, for a little context, with the Green Communities Program, which you may have noticed Lisa said she was the Green Communities Coordinator. The Climate Leader Community Program was an offshoot of the Green Communities Program. And you may recall or know that in 2015, the town was designated as a green community. And that designation was the culmination of a few years of work by the committee, by the Energy and Sustainability Committee, but supported by other groups and individuals within the town. For example, town meeting approved 2 articles that were required to become a green community. And the select board also approved 2 policy items that were, again, required to become a green community. And did check back, and I'm happy to report that select board member McCrisky was one of the members who voted in favor of both of those policy items that made us a green community. Once we were designated, the town received a a large designation grant. The subsequent grants were directed by first Paul Jaffoon, who's also still with the town, and then subsequently they've been taken over by Kathy Stanley, the town's energy manager. And we can do next slide. And when Stoughton came in as a green community, of the 351 cities and towns in Massachusetts, we were actually about 150th to come in. So we were, not exactly leading the pack, but in the first half. So we, I think made a good decision at the time to get as much benefit out of this program as we could. You can see here that since 2015, over the 10 years since Stoughton's been a green community, we have been awarded over $1.2 million of grants from the Commonwealth, from the Department of Energy Resources, that's been used for energy conservation, weatherization, HVAC upgrades. So just money that has come in from the state that we wouldn't have had otherwise. And I think it might be interesting, you might be interested to know that a good chunk of that money was used here in Town Hall for weatherization, for HVAC upgrades, for HVAC control. So we're literally enjoying the fruits of the Green Communities grants right now here in this building. Then the program really has been great for Stoughton, and I think it's been great for the Commonwealth. We're not the only town that's taken advantage of it. You can see now there's 297, so not all of the municipalities in the state are members, but most of them are getting there, and we were in the first half, so good for Stoughton. And I think I can say that because of that success, DOER has decided to bring forth a new program called the Climate Leader Community Program as a way to keep the momentum going, give towns the next step to go forward. We're very excited about it here in Stoughton, and on the committee, I would be happy to talk about this for a lot longer, but luckily we don't have to because we have one of the Commonwealth's experts right here, Lisa Sullivan, again, the Southeast Regional Coordinator for Green Communities. So Lisa, you can take it from here.
Sure. I had the opportunity to meet with the Energy Committee probably in August, did a presentation to a few of the members and explain the Climate Leaders Program in detail. We're calling it's Green Communities 2.0. So people were asking for more. Towns were asking for more. What can we do to help reach our ambitious climate goals, sustainability goals, energy efficiency goals? So we came up with this program. It's very similar to the Green Communities process. And after the Energy Committee heard about it, they asked, could you come in and talk to the town manager about it? And so we set up a meeting, and we met with Tom about a month ago, Town Manager Coulter, and it was a very successful meeting. He seemed very enthused, and he said you should, reduce your presentation to a few slides and bring it to the board and see if they agree that this is something we should, go after. So I'm here tonight to tell you a little bit more. So when you became a green community, you had to meet 5 criteria, and those were to establish a zone with renewable or alternative energy, light manufacturing, or R&D. You got to pick which one. In that as-of-right zone, you had to have rules and regs or local permitting that said that you would process those applications that checked all the boxes within 365 days, which you did. You established an energy use baseline for all your municipal operations and fleet, water, sewer, street lights, buildings, et cetera. And you made the baseline in Mass Energy Insight, and you created an energy reduction plan that showed that you could reduce your energy use in your buildings by 20%. Then you adopted a fuel-efficient vehicle policy that said you're going to try to right-size and clean up your fleet, which you've been working toward, and you adopted the stretch code. The Climate Leaders builds on those criteria by making additional criteria that you have to meet to get a Climate Leaders designation, and those things are you have to have a local energy committee. You have to be a green community in good standing. You work on a decarbonization roadmap, which basically, it looks at your buildings and says, how can we reduce our greenhouse gas emissions? You use zero over time philosophy and triggering events like We need new equipment, new HVAC, new roof. You look at the existing conditions and you say, let's make these changes when it makes sense. And then criteria 4 would be a ZEV first policy, which is you'll always look at an EV first, a plug-in hybrid, a hybrid, and then if those things don't work for you, you fall back on the green community fuel efficient vehicle policy. So that's the backstop. It's important to say that police vehicles, emergency response vehicles are still exempt from the policy under the green communities, and vehicles over 8,500 pounds are also exempt. And then the last thing is you have to adopt the specialized opt-in code at town meeting. And I know you have representative town meeting, so that's a general bylaw. It would be an ordinance or an ordinance if you had a town council form of government, and you would just need a majority vote for that. We can move to the next slide, please. So this is just telling you that we have 19 climate leaders designated. So of our 297 green communities, 19 have pursued climate leaders. The program was just announced like last year. So we had our first round of climate leaders. We're anticipating up to 10 more in June. So we should be up to around 28 or 29. And we wanted to present this program to Stoughton because you're doing all the right things. You have a really great energy manager. You just received recently, I think, a Greener Schools grant. You're applying for TESI grants. You've reached your 20% goal for reducing energy use in your buildings and facilities. And we just see a lot of promise, and we wanted to invite you to consider the program. Next slide, please. So why would you want to be a climate leader? Leading by example, public recognition, be one of the first. It helps you get the resources, the funding you need to meet our ambitious goals. Helps you get the funding you need to do work in your buildings and improve your existing buildings. And also, it supports community engagement and gets the word out there. This program has some advantages that the Green Communities program didn't have early on. So there's some funding to reach out in the community. Next slide. And what is the carrot? The carrot is the climate leaders have $1 million accelerator grants. When a community becomes a designated climate leader and meets all the criteria, they're eligible for a $1 million accelerator grant. It can be used in existing buildings. It could be used on new construction buildings. If you had a big project coming, you could put the money toward that. It also can be used to add solar PV or battery storage to existing electrified buildings. There's also a $150,000, technical assistance grant to further look at buildings for opportunities. Next slide, please. And then we'll get to the future action items.
Yeah, so, sorry. We certainly will give you, happy to stay as long as you want us for questions, but we're keeping this short. So, again, as Lisa said, we did meet with the town manager about a month ago, and I don't mean to put words in his mouth, but he did say he was very favorable to this and thought it would be, a good thing for Stoughton to look at. We thought, it made sense to talk to the town manager first, and he agreed that coming to the board second also made sense. So, we're trying to respect the process and appreciate all the support that we've received from you in the past. So just very briefly, kind of 3 future action items. They're starting this month and going into 2026. So the first item is in order to meet the decarbonization roadmap, DOER is offering a grant to support, can you talk about it? Would be the work done by?
There's a roadmap, technical assistance that's available. DOER funds it. We would assign a consultant if the town applies at the end of November, for example. There's an application deadline. What we would need is we'd need the town manager to sign it and say he was trying to pursue, the town would try to pursue climate leaders designation within 1 year. If you wanted to do that, we would assign a consultant. It would tell the boxes that you've checked. The boxes that you've checked are you have a clean energy committee, you're a green community in good standing, and you have a municipal commitment to decarbonization, and that's your climate action plan that you're working on. You're committed to creating a climate action plan. We see that as a commitment to decarbonization. Then this roadmap would be prepared by a consultant and presented to the Board of Selectmen and the school superintendent for approval. Just like you did your energy reduction plan back in 2015. And then you would have a ZEV first policy, which is the updated fuel-efficient vehicle policy that would, like I was talking about, it would prioritize battery electric vehicles, then plug-in hybrids, then it would fall back on the green communities fuel-efficient vehicle policy that you already have. And that would have to be adopted eventually by the select board and the school superintendent or school committee, whatever the superintendent desired. And then you would have the specialized energy code, which would be an article before a town meeting, which you could consider in the spring of 26 or the fall of 2026. And so we would be looking for support for that. And we would provide public education so that people would know what they were voting on. We'd bring a code specialist. We would educate people, educate the board, the planning board, the building official, et cetera.
So the first step is the grant. So we would like to get going on this in November if possible, and certainly don't want to move forward without both the town manager and maybe even more importantly the board's approval and support. We're advising you as a committee, and are not going to move forward without the board's support. So that would be the first action. Just if the board could in some fashion transmit to the town manager that you are in support of us going after that grant. The other items which come later would be being willing to consider the zero emission vehicle preferential policy. We would come back to you and talk about an article before town meeting, whether that would come from us or from the board. But it's really just a stepwise process. There's really no commitment until you get to the end. It's not like if you start, you have to give the money back or have to go on a certain schedule. So I think that's basically it. If we can ask you to consider if going this next step from the really great success of the Green Communities program, taking the next step into the Climate Leaders Community program, with that first step being support for the grant. So I think that's it.
Correct.
Thank you.
Thank you. So we'll ask if any of the board, members of the board have any questions for you. Ms. Roberts?
Yes, Mr. Chairman. Thank you. This was a great presentation, and I am in support of it. But I do have a specific question, and is your idea, I guess, to be more granular about the request and what you propose to do? Is it in reference to putting more for electrical vehicles, charging stations in the town? Is it to assess if we need more lighting throughout, especially downtown, because it looks really dark? Or how about in the buildings, like in this room, in the Great Hall? It's always so dark. So would you do an assessment like that? So does your proposal go that far, or is it something else?
So it probably the entire process touches on everything that you mentioned. The roadmap is a planning document that would talk about getting away from fossil fuel use in both the town-owned buildings and town-owned vehicles. I would love to talk more, but I want to take advantage of
notes. I will mention to your energy manager, Kathy Stanley and Paul Gaffoon, that these things came up at the meeting that you'd like to investigate. Green Communities could do that for you. We could look at the wattage in the lighting in the buildings and see if we could make improvements that will save energy, maybe with like better LED lights or more advanced LED lights, or adding controls or something to that fact. And they could look at the downtown lighting. We don't usually add lighting, but perhaps looking at if there could be augmentation for lighting, if that would make sense. And also, you mentioned charging stations. Green Communities does help pay for charging stations. There's also the EVIP grants through through the Department of, I'm sorry, it's not coming to me right now, but there's the EVIP grants as well. So that would be a thing that you could pursue as well, and I'll mention that to Kathy and Paul. Climate Leaders is really focusing on reducing fossil fuels, decarbonization, meeting our long-term and ambitious energy goals. So we have a climate action plan in Massachusetts. We're trying to, on a roadmap, we're trying to get to by 2030 and 2050, eventually to net zero. So in doing that, we need to make significant reductions in our fossil fuels use in our buildings, especially the major users like the schools in those buildings. If we could reduce electric use or natural gas use and make the buildings as efficient as possible, eventually they may be able to be served by renewables, which would be helpful.
Thank you, Mrs. Sullivan, and thank you, Mr. Billow. I have no further questions, Mr. Chairman.
Thank you. Any other members have any questions? Mr. Gio, do you have any questions?
Yes. Putting up solar panels, things of that nature, is that something in your bailiwick, or is that something that was something long past?
Climate Leaders does provide solar PV funding. It's part of the program. So if you have an electrified building, you could use the Climate Leader Accelerator Grant or future grants to consider adding solar PV to buildings that are electrified, and to consider battery storage as well. So those are options. Some towns are using them if they're doing a new construction of a big school. They might try to add geothermal and use their money for that. Or they might try to add a state-of-the-art HVAC system that has really excellent ventilation and is all electric and provides heating and cooling to the building. So many opportunities to use the funding. Just similar to like what you've done with Green Communities funding. You've done some heat pumps and LED lighting and VFDs and transformers, and you've done controls, energy management systems in buildings. Climate Leaders just takes it a step further toward decarbonization.
With a guaranteed $1 million available grant
Right.
once we are designated. So it's, that's one, we double our money essentially, or almost, with this next step. So it's not completely easy. We have to follow the 6 steps, but as you may have remembered from the second slide, we've already got 2 done just from work that we were doing anyway. We're almost done on the 3rd, so we're almost 40% there, just right off the starting line. So,
What are things that are particularly productive in terms of reducing our carbon footprint?
Electrifying buildings, reducing your fossil fuel use, and some communities are not moving completely away from fossil fuels. They're doing things like hybrid heat pump rooftop units with controls, where they substantially reduce their needs for fossil fuels. That's an example. We're seeing more and more opportunities for charging stations and electric vehicles in communities. The LED lighting, VFDs, which help motors like motors, they allow them to phase it, like shift downward, I guess, and be more efficient.
So your planning would provide sort of a roadmap for the things that we might be able to do that, and the things that are most cost effective in that regard?
Correct. This roadmap was kind of a plan. It's not, it's going to look at your existing buildings, try to look at the ones that are making the most emissions, and then they will try to look at the existing conditions in those buildings and see what the triggering events are, when the best time to make changes and to consider changes to those buildings. You wouldn't want to make major changes to a building that you were going to remove from your building stock, or you were unsure if you were going to keep it in your building stock. So you would want to, you would lay out like your capital needs and plans for a building, and you would look at if we're going to redo a roof, we should evaluate for solar PV and battery storage. If we're going to look at the roof, we should make sure the roof is insulated. It's a time to think about adding or improving the RT, like the rooftop units, for example, and the systems up there.
Mr. Brickerski, do you have any questions? Thank you. So I just have a couple. And first one's going to, you have to excuse me. I've been burned before. That's why I'm asking this question. But the accelerator grant says up to $1 million. Whenever I see that, it kind of piques my interest. Do we have sort of like a minimum, maximum, or like where things tend to average towards, or is it typically close to $1 million?
So far, we're encouraging people, when I go out and I talk to people, we're encouraging them to come in for the full $1 million. There's one bite at the apple for that first $1 million grant. It's not like the Green Communities Designation Grant, which was it was a formula that included per capita income and population. So your grant, if you were Boston, you would have received $1 million. You received, I think, $290,000, if I recall, something like that. But that was a formula fund that we did. It was like a little equation. This one, it's a good carrot. It's $1 million. And so rather than the Green Communities Designation Grant allowed you to kind of learn the process and come in for one project at a time up to that $290,000. Here, these projects are expensive and people are coming in for the full $1 million. They're either putting solar PV on an electrified building like a school. They might be building a new building with MSBA funding, and this is going to help reduce their contributions so they know where that $1 million will go. So it's something like that. So you would be encouraged to come in for the full $1 million and then to also apply for technical assistance either for that first project or for, if you knew what you were going to do, to come in to consider mapping out your next project.
Thanks, and thanks for indulging me. It was like my own personal history, creating anxiety, and you helped me to get past that. I appreciate it. So everything about this makes a lot of sense to me. I think because we're already doing a lot of the work to begin with, why not just take a couple additional steps to get there? And I'm definitely on board with it. Also, when it comes to the specifics, it's helpful for us to know them, but ultimately this is going to go through several layers of analysis. So if somebody catches something that's really doesn't sound like something we ought to get involved with, we're going to have plenty of opportunity to explore it. It's got to go before town meeting. So we don't have to make sure that it's flawless at this point. And my point is really, does it sound like, in my mind, the question is, does it sound like something that the town ought to consider pursuing? It really is the vote, right? And if we ought to consider it, let's get going on it and see what comes out, what we learn, and what problems we run into. The one thing you've ultimately presented a number of financial elements of this that are beneficial. There's grants availability, and I think it helps a lot of people to really tap into that more. I think, and just more of a suggestion, is one of the things that I've discovered through learning more about these types of projects is how much they actually really can save people money in the long run. And there's people who are going to approach these types of these initiatives because of the morality behind it, which I tend to appeals to me, right? We're fish living in a tank, and it gets dirty, and it's because of us, right? And so the question is, what can we do to maybe not create so much damage? I have a son, and there's people who are going to be inheriting the world from me, and I can't help but feel sympathy for what I've left behind for them to deal with. But for some people, that's maybe less of a incentive, because it seems so abstract, and well, yeah, I mean, things have always been bad, but remember the smog and acid rain? We don't have those anymore, so maybe we're doing pretty good. I don't know. But when you hear, for example, that you can cut your utility bills in half, like okay, well, let's talk more about that, right? Because those are the kinds of things that really hit home right away. And though you touched on a number of those things, I'm sort of like I'm not asking you to do it now, but I'm like more intrigued. Like, hey, what else? Like, what other ways can we find to make this town cheaper to run? And hey, we also have this added benefit of the fact that we're not going to leave a wasteland behind. So I just want to kind of ask if you present again, I'd love to hear more about those kinds of projects.
Sure. The decarbonization roadmap will have some suggestions for where to start, where to prioritize with input from the town and boards and committees and those kind of things. Of course, Paul would probably be a key person who would weigh in on that as well. The select board would obviously get to look at it and approve it. It would have some cost generalizations about what certain projects might cost. And then with green communities, we always do that. Whenever a project is proposed, we look at the project cost, the available incentives, the energy savings and maintenance costs, all of those things, and we lay that out project by project. So it's very present of mind. And we will definitely, for example, if we were doing specialized opt-in code education before a town meeting, we would actually present more information about the costs and benefits of that at that time. It's always evolving and changing based on, we change some of our economic slides based on like the interest rates, what the tax credits might be. For example, a heat pump rate became effective very recently, that anyone who has a heat pump will receive a 6-month heat pump rate from the major investor-owned utilities. So things like that will all play into updating cost slides and the economics and why it makes sense.
Yeah, I don't want to change topics here, but one of the things I've recently, probably in the last couple of years, become aware of is passive housing. And where you can essentially, eliminate utility bills. Maybe you'll have electricity, but they're so well insulated, using sort of NASA level insulation that you don't even need, heaters or air conditioning. It's quite amazing what people have come up with. And those construction costs are not all that far off from what standard construction costs are. So it costs about the same, and it's cheaper to run. Plus, they have a useful life because they have very little exposure to the elements. A useful life of 100 years versus 50. So it's sort of, when you hear about these projects and things people are working on today, that also has this additional effect of being cleaner. It's remarkable. So I appreciate it. Do you need a vote tonight, or it might be? I don't know if people want to ask questions.
It really is a vote that's needed. It's the support. We're just looking for support, and you express that to Town Manager Coulter so he feels comfortable signing an application and saying that the town wishes to try to pursue this. You would be voting along the way on things like a ZEV first policy, and we'd be asking you to put forth on a future warrant the specialized option code, where you would learn more about passive house and and the education about the specialized opt-in code, because we certainly would want you to feel comfortable with it before you would bring it to town meeting sometime in 2026.
Thank you.
Mr. Chairman,
Yes.
it may be helpful if we just had a motion and we approved it, just to show Mr. Coulter.
Perfect.
Okay.
You want to make a motion?
Oh, sure, I'll take a stab at it. I move that we agree to allow that we show support for the future actions of the climate leader community, David Bowell and Mrs. Sullivan. So the Energy and Sustainability Committee Chair.
Okay, thank you. Is there a second? Okay, motion was made by Vice Chair Roberts, seconded by Mr. Carrera. All in favor? Aye.
Aye.
Any opposed? Any abstentions? Looks like you guys have a unanimous vote. And I know this is the fun part where you get to build up support, and then you got to do all this hard work that is never ending, and so enjoy it while it lasts. But thank you very much for providing us this presentation.
Thank you. That was an excellent conclusion. Unexpected, but really appreciate it. So thank you. And just in closing, the committee is a lot of the same people that were around in 2015. We went through the green communities, moving the town toward that. I think we love doing that. So we're kind of warmed up to do it again with climate leaders, and with support like this, we'll get it done. So thank you very much.
Absolutely. Thank you so much.
Thank you very much for your support.
Of course. The last order of business, and also before you leave, thank you again for your patience. I really appreciate it. The last order of business is a consent agenda. We have 2 items: approval of open session minutes, meeting of October 9th, 2025, October 21st, 2025, and October 23rd, 2025. And item B is a letter of support, BAT Avon Stoughton Community Transit Grant Program application.
Second.
Okay, motion to approve was made by Mr. Gito, seconded by Vice Chair Roberts. All in favor, say aye.
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 Motion to adjourn? Second. All in favor? Oh, I'm sorry.
It's old habits. So there's a motion to adjourn made by Vice Chair Roberts, seconded by Mr. Carrera. All in favor, say aye. Aye. Have a wonderful evening. The time is 10:07.